Hi there, I'm going to answer one of your burning questions around understanding Article 4 restrictions. I get asked this question quite a lot when it comes to houses of multiple occupation, because when you're doing a house of multiple occupation, or better known as an HMO, there are two things that you might need to consider. One is the HMO licensing, which is generally dealt with by the HMO officer in your local council. However, there is another point that you may need to consider, which is Article 4, and that's dealt with by the planning department. So although the two might apply in relation to an HMO, they are both actually dealt with by different departments. Now, Article 4 doesn't apply in every area, so you do need to check with your local authority whether it applies in your area or not. But the general ruling around Article 4, if there are restrictions when it comes to that, is that it looks at, do you have 3 or more unrelated tenants in your property? And if you do, and you're in an Article 4 area, then you need to get planning permission. So there are areas like Leeds and Nottingham, Manchester, where you may need to get an HMO licence for a property, or it could be a property where you don't need an HMO licence. You might have 4 tenants across 2 floors. But if it's in an Article 4 area, you will need to apply for planning permission for that property. So what I'd recommend you do, in order that you understand what the restrictions are, is contact your local council, or you can go online, sometimes the information's there, and just find out, do they have Article 4 planning in the area? You can often find a map that draws out the area that it applies to. And if you really don't understand it, contact the planning department and just ask them some questions around it so that you can get a better understanding. Because really important that if you have 3 or more unrelated tenants and you're in an Article 4 area, you will need to get planning permission.